everyone, this is Steve Rosenberg with Mynd Property Management. Today I am joined with Giles Imrie, who is head legal counsel for Mynd Property Management. Giles, thanks for joining me today.
Thanks, Steve.
So today we want to talk about, we've had another video talking about the new law that is going into effect in Oakland and very likely in other cities, possibly in California, about running background checks on your resident and how it is no longer allowed legally to do in the Oakland area. And today what we're going to talk about is what are the ramifications of doing that if you do it and you should not do it. So Giles, why don't you fill us in on that and give us your perspective and what the law states?
Sure, thanks, Steve. So yeah, this is, as Steve mentioned, this is the Oakland's proposed new ordinance called the Fair Chance Housing Ordinance, which prohibits, it's expected to go into effect next week, and assuming it does pass final vote, would prohibit landlords, property owners from using criminal background checks in their application screening process. And we talked in a prior video of some of the nuances and exemptions that are available, but generally speaking, you can no longer perform criminal background checks outside of verifying if somebody's on a lifetime sex offender list or in subsidized housing. But one of the important pieces of this new ordinance are the implications or the penalties that are available to tenants or going to be imposed on landlords if they foot fault in this ordinance in any shape or form. There's some requirements on no longer to advertise or require criminal history in your application process, and then just the ordinance itself. But right away, the statutory penalties for violation is $1,000 for each violation that would be imposed by the city itself. But what's really catching in here is that it also affords any applicant that feels like they've been wronged under this ordinance the right to a civil private action in which they're entitled to monetary damages that are the greater of 3 times the actual damages, including emotional distress. So that's a big one, emotional distress. Every tenant or applicant's going to claim that they've been emotionally harmed if they were wronged under this ordinance, or 1 month's rent. So 3 times the market rent you had for that unit. So if it was, say, a $2,000 rent or a $3,000 rent, you were right up to $6,000, $9,000 in statutory damages, plus attorney's fees and costs. So anytime you have a penalty provision like that, you're just immediately attracting landlord-tenant attorneys that are just going to be looking for minor violations. You're going to get a demand letter that says, I'm entitled to 3 times my monthly rent, that's $7,000, plus $2,000 in attorney's fees that it took me to write this letter and meet with my client. And so there'll be a lot of shakedown letters I'm envisioning around this ordinance where you're going to get a demand for $7,000, $8,000, $9,000 just to make it go away, which is that's an unfortunate piece of this legislation, I think. For that
and just so I understand, Giles, is it the greater of the two, the emotional distress and or the rent of 3 times the amount, or is it and?
It's the greater of 3 times either actual damages, which includes emotional distress. So, okay, but that's a very loosey-goosey amount that people claiming that they've suffered harm as, or 3 times the listed rent, or the amount of HUD's fair market rent for small area, just in case you had a lowball rent. In most instances, it's either going to be 1 or 2, which would be the 3 times the amount of the advertised rent, or their claim for actual damages and emotional distress.
Wow. So, and like you had said, I'm sure this is going to be pretty fast and swift, especially with other people, advocacy groups and other things. If you could, what advice or would you give to an investor that has a property that's sitting now thinking, what do I do? I've got a vacant property coming up and I don't even know what I should say or not to say just to keep myself out of any legal implications.
Well, I think the first thing you can do is to make sure your advertising material and your application portal or application documents, if they're manual and physical documents, include specific disclosure that you no longer require criminal background checks within the city of Oakland, or otherwise prohibited by this Fair Chance Housing Ordinance. So right away, you're just making a disclosure that you're not going to do it. So there isn't an inference where somebody's going to peruse your website and say, hey, you advertise on here that you don't rent if there's a criminal history. You've got to make it clear that in the city of Oakland, you're not going to require a criminal background check unless it's otherwise allowed under this ordinance, which would be for sex offender list if it happens to be exempt for an owner-occupied single-family home, duplex or triplex, or if it's federal subsidized housing, in which case you can also screen for manufacturing of methamphetamine in addition to the lifetime sex offender list. And then just making sure that your process, if you are doing criminal background checks in other jurisdictions, has the sophistication and ability to recognize that you're dealing with an applicant from the city of Oakland, and you're not going to do that until you've gone through all these other hurdles, otherwise approved them and gotten their consent to do the sex offender check. Or if you're dealing with subsidized housing, do the methamphetamine criminal background check.
Sure. Wow, that's great information. And so again, this may not be the only city in California. So this information, while it's relevant and pertinent to Oakland, very well could quickly spread to the Bay Area as well as other cities, because this is obviously a challenge with housing, that many people cannot get housing, and this is a solution that certain agencies feel that this is the way to resolve it. So, great information. If I owned property anywhere in the area, I'd make sure that I understood the law, knew the law, and at least could make sure that I'm doing whatever I have to do to stay out of the crosshairs, if you will, of some of these agencies. Some of it could be handing your properties to Mynd Property Management, where we could help you out, and you don't have to learn or worry about that, and allow us to take care of it. Any closing thoughts, Giles, for our watchers?
No, I think you hit it. This is something definitely to keep an eye on. We know it's coming in Oakland, but as you said, Berkeley, I know, is working on something very similar. And anytime you get one or two jurisdictions that implement something like this, there's always copycat legislation that's gonna breed from there.
Yeah.
That could take on just nuances or variations of this, or their own variations.
Yeah. So definitely be on the lookout for this. Make sure you're staying abreast. If you want to go to our website, it's mynd.co, Mynd.co, where we'll have as much of the latest information as we can on there to at least educate you. And if you'd like to talk to someone about having Mynd manage your properties, we can definitely do that there. You can schedule a booking right there and schedule a session. So on behalf of Giles and myself, I want to thank you for watching, and we'll see you later. Bye-bye.